process. We are not here to convert each other, take a sense of all the points and then build a consensus. Otherwise, it will be impossible to answer these things. We can write essays and reports on these things.
Important point, sir. Just take 15 seconds. You have a Mauritius-India double taxation agreement, which is responsible for laundering of lakhs of crores of crime and sleaze money into India.
That was struck down by the Delhi High Court.
Yes, sir. Yes, sir. Yes, sir. Yes, sir. More important than Jan Lokpal bill ever can achieve is to strike down the double taxation India-Mauritius avoidance treaty. We have let the main gate of the all criminal narcotics mafia on for last 30 years. Now question is, you have finance ministers here, one after another. Some of them wanted to... Sir, just 1 second, sir, just 1 second. Sir, give me a second. Now question is, when you enter into double taxation avoidance agreement with bogus countries like Mauritius, and I can give you Cyprus, I can give you, all of them are meant to bring the sleaze money of these politicians and criminals back into India. What is Jan Lokpal bull going to do about it? He must take into such treaties into his own account. What is the purpose of leaving a floodgate open like that and talking about clerks and other corruptions?
The government is signing FTA without the...
We all have a lot of bias. There is no one answer to all. There is no silver bullet. There simply is no silver bullet anywhere in the world.
Couple of suggestions I have regarding this amendment you said. See, one is regarding the punishment. 19A of the Jan Lokpal bill talks of punishment. So this Lokpal bill talks here, it should be amendment in the PC Act, life imprisonment, all that. We need not discuss in this Lokpal bill what should be the punishment. PC Act needs amendment, whatever punishment you want. And in fact, I also agree it should be life. Now this is the time that depending upon the magnitude, the court can give life. If the magnitude is like Raja or whatever. So this amendment has to be in the PC Act, not Lokpal. Secondly, what is required is the presumption clause of Lokpal, this PC Act also is to be amended. Presumption clause, section 20, talks of presumption where public servants accepts gratification other than legal remuneration. So there is a presumption that if you are caught taking bribe, it is presumed that yes, it is a bribe money. Unfortunately, in this clause, what is not presumed is if it is disproportionate offence. More than taking money is the money which you have acquired through the, you are caught in one instance, but 20 years down the lane you have been indulging. So that also should be brought here, that if disproportionate assets are found, which are disproportionate to your own known income, then also there should be a presumption that this is illegally acquired money. This presumption should be, yes.
The law went through a lot of change. Earlier, under Section 5 of the Prevention Corruption Act,
yes,
there is a presumption, but later on they made it a substantive offence. If possession of assets disproportionate to known source of income raised a presumption of misconduct. But later on, I think in 1961 or so, the Act was amended to make it a substantive offence.
Yes, may not be substantive offence is there, but despite substantive offence, presumption of culpable mental state also should be added. That is what I am saying. It is a substantive offence, so therefore substantive offence would be sort of proved. The moment disproportionate assets are recovered.
You are suggesting a rule of evidence now.
Yes, culpable. Like in Customs Act, Income Tax Act, FARA Act, Excise Act, all they have culpable mental state presumption. So corruption is more serious than custom and all that. So culpable, and it has stood the test of judicial scrutiny. We all knows that.
You see, earlier it was 51D. 51D. You see, now it is some separate provision.
About disproportionate.
Exactly.
Yes, 13(1)(e).
You remember?
Yes, that is what I am saying. There should be culpable mental state presumption also.
In 1964, in the Gills case,
yes,
the question arose whether retrospective penal legislation, because they took 10 years previous assets and income and assessed it. Then they said the amendment came only in 61, you can't go take my assets acquired prior to 61. Then they made a distinction between retroactive and retrospective legislation. and then said by drawing these things from backwards is not retrospective criminal legislation, and in that Gill's case, 64, Supreme Court, 1964, they said that the presumption became a substantive offence itself.
That was the case. Presumption became substantive.
Second, which is most important, is now after a couple of days they get bail. So the provision which is there in NDPS Act, that no bail unless the judge holds that I reasonably feel. NDPS Act has this provision, we all knows that NDPS Act bail is to be granted only when the judge is satisfied that no offence is made out. If the judge has reasons to believe. So same provision should be brought in Corruption Act also, that no bail unless the judge feels that this is a false case. This is very important because they get bail and for donkey's years this continues the trial. This amendment also I feel is required, but it can be taken from NDPS Act.
Justice Sharma will address this question, I think so. But my appeal is, if you try and substantially change the basis of criminal law of this country.
No, it is there in Customs Act, Excise Act.
No, but how
But no.
has it been?
See, there are all kinds of fears in the country. Therefore, upset as few people as possible.
There are precautions.
We will not upset anybody if we don't pass the Lokpal bill.
No, see, don't take extreme positions. Have a balanced appreciation of the realities of this country.
I have a point.
Or any country for
This
that
point is
matter.
extremely
I mean,
valid.
yeah, it's okay. There's also another point of view. Point is we have to be a little more in our anxiety. On the one hand, we are saying Lokpal officials can become draconian fellows. Other hand, we said Lokpal should have all the powers.
All the draconian powers which have been consistently misused for decades.
So
And
let there be
produce
some
a very
reasonable
corrupt
balance.
regime.
An independent, strong, robust institution is one thing. Trying to burden everything and then suddenly expecting miracles is another.
No, but I don't accept this argument that it is all right for the government to have draconian power against people, but not all right for government to have draconian power against corrupt government. It has to be valid for them.
Anyway, your point is taken.
I have a suggestion to make.
Sir, I just want to make some very important point.
One second, let me say.
My request is instead of going into all these things at this stage, we can perhaps insert in the bill that it should be the responsibility of Lokpal to study all these things and make suggestions to the government from time to time. You can't visualize the whole thing at this stage, you know. Let's put that responsibility on Lokpal. From time to time he will study and make suggestions to the government for strengthening the law. That's better, I think.
A bit like law commission in respect of anti-corruption laws.
Sir, just I want to make a very important point. Sir, we have so many regulators, in every sector. And they are being immunized against, you can say prosecution. Also, their tenure is also just like they cannot be easily removed, and they are the main source of corruption everywhere. And sir, our Lokpal bill, you should focus on these regulators, because all the corruption is happening through these regulators, whether it is power regulators or telecom regulators. So we should target these people. If we are going to target politicians, nothing is going to happen, because politicians going on changing, prime minister may not be.
Regulators come under jurisdiction of Lokpal. So there's
Sir, we must focus on that.
constitutional authorities we are re-examining. Otherwise, regulators come under the Lokpal.
They are the main source of
It's a
corruption.
point is well taken, but that's already covered. So the point, the issue is covered.
Sir, I would like to make a point which was not discussed here. The point is, when I go and make a complaint that I have paid a bribe, today I am prosecuted first, and the person to whom the bribe is given is only an allegation. So this should be removed so that more and more people will come and complain about the problems of corruption.
Prime Minister's advisor also.
Would you like to comment? ARC has examined this issue. There are two forms of corruption. Extortion. Collusive is where the bribe giver is as guilty or more guilty. Extortion is where the bribe giver is actually a victim. Therefore, there is a case to re-examine, but again, these are complex issues of anti-corruption law. If you bring it under Lokpal, it becomes too complicated. But the point is well taken. So, then sir, we would say that 11 and 12 issues are covered adequately. Item 13 is covered now, Prevention of Corruption Act. Do we take on board the points made by Vinitha Roy about corruption? Definition of corruption to that extent that ARC suggested. Item 14 is already covered, Single Directive of CBI, Section 6A of the Delhi Special Police Statute Act is already covered. Item 15, effective prosecutors is covered. I think the view is that the Lokpal and Lok Ayuktha should have the complete power to decide. Item 16, sir, only procedural issue, but we would like some idea. Really, I think we are in good time, so that we have some 20-30 minutes time left for any other issues that may have to. I'm sorry for being harsh on occasion, but there's no way we can complete so many issues. Confiscation. That's why in the PCA Act, ARC suggested that if a confiscation is a very critical issue. You must look at the clock, sir, and then
15 seconds, sir. Yeah. You see, the Constitution of India came into existence in 1950, as the excellencies will know. Directive principles have remained on paper. 63 years have passed. Preamble has remained on paper. Let us have a simple definition of corruption. Any act which goes against the spirit of the Constitution, principles of state policy, directive principles of state policy and preamble shall be deemed as corruption. Because otherwise everything is going to remain on paper. Because you see, corruption is not just act of exchange of money. The society is basically corrupt in 3,000 ways. Anything that defeats the purpose of the Constitution of India shall be deemed as corruption. That's all I want to say. No other definition will work.
Then every case will become a...
let it be so. Let it be so.
Every official will be subject to corruption.
No, we can't define.
90% of people in India are corrupt.
That is our assumption that we cannot do anything about that. Respectfully disagree.
That is strongly objectionable statement.
Okay.
That's not true.
Item 16, sir.
There's no basis for
Should there be time limits imposed on the Lokpal and on the criminal courts in order to dispose of cases between a special courts issue?
Actually, question of imposing timeline has not worked. I mean, under the Representation of People's Act, election petition 6 months doesn't work. What can work possibly is, if you mandate in the Act itself that the number of courts required for dealing with these anti-corruption cases shall be assessed by the Lokpal from time to time, on the basis of which they will recommend how many courts need to be created for dealing with these corruption cases, these special courts, etc. And that many courts, the government would be mandated to create that many courts or provide funds for those many courts within such and such a time. Some such provision can be made. What do you say, sir?
Also, that is for functioning, independent financial.
That's a fair and reasonable thing. Nobody should disagree with that.
No, it's exactly that, because I think the cost
that point is well taken. There's unanimity on that. There's a desperate need to increase the number of courts.
What constitutes corruption actually is derived from two Latin words, cor and rupt. It means seriously ruptured. So it's a very wide definition.
Election disputes to be decided within 6 months. And no dispute, excepting in one case in 1977 or so, the Chief Justice listed the entire 40 election trials in my court, my land, and disposed them off in 6 months. And that's the only record that is available on this. No case, 5-year term was over and automatically it became infructuous. This is a very important thing. As a matter of fact, every legislation is now bidden to say not merely the financial impact, the impact on the judicial personnel, the judicial resources, how many courts are necessary, what is the anticipated litigation that will generate, all this kind of thing. Judicial impact statement must be mentioned in every statute. Here you must provide expressly, otherwise you know what the funny thing happened. In the Industrial Disputes Act, they said you must stop in 6 months. When it was not decided, one of the parties took the question, you have no jurisdiction at all. 6 months are over, you are pacta sufficio. Then Supreme Court had to say, no, this is a guideline, you don't lose your jurisdiction. So this is a very important point. I think how to frame it is the genius of the draftsman.
There is a larger issue.
Mr. Manjush Sinha and then
I just wanted to put it in perspective. The average time taken in a CBI case today is 10 years. It's 10 years. And the final conviction, that means somebody going to jail, we did this survey for 3 divisions, is 4%. So let us keep this in mind.
10 years after the charges are framed? I mean, actually the court.
Yes.
No, I have a point to mention there. See, you see, the Criminal Procedure Code was designed and enacted in 1898. Now communications, technology and all have improved tremendously. But even today, I know from personal experience, even in cases against the Naxalites, for appearance of accused, we have had cases adjourned for 40 times, 50 times. For mere appearance of accused. We don't have trial in absentia, where the accused is willfully absenting himself. So, unless we thoroughly amend the Criminal Procedure Code, there is no way we can expedite the disposal of cases. Cases will take 10 years, 12 years, because there are 100 ways by which an accused will dodge the hearing of the case. Witnesses won't appear, then it is adjourned for appearance of witness. Medical. Then medical. So many things are there. We have to provide for trial in absentia.
Thank you very much. There are just 2 points I'd like to make. One is, I'm Mazhar Hussain from Kowa, Hyderabad, Confederation of Voluntary Associations. One is, very interesting discussion, but one aspect which we seem to have left out is, in India we've got the government officials, politicians engaging in corruption, and also we have the private sector engaging in corruption. But unfortunately, I think we also have extra constitutional bodies, individuals. How do we deal with them? And it's a very, very major thing. So how do we bring the extra constitutional bodies also? And responding to Shanti Bhushan ji about continuous process, already we have been discussing with different states. We are planning to have state level consultations planned in all the states between 10th and 25th of May. And we will try to involve people from various backgrounds, including trade unions, professionals, NGOs, activists and everybody. And then I was also discussing with Shanti Bhushan ji also, with Prashant Bhushan ji also, that if some of the members of this committee, of your committee, can come and participate in these things, I think it will be really very good. It will be a process by which we can really reach out to all the people and give them a chance to participate. Thank you.
Maya.
Thank you. I have one clarification to seek, again the same question really, and a comment to make. We must look at the Lokpal bill we've looked at it in many aspects, but one of the aspects that we should look at is what happens if you don't have a good Lokpal, or you don't have good set of Lokpals, or they are beset by problems. So my question again would be, you put in timelines. There are timelines in the Criminal Procedure Code, there are timelines with the fast track courts, none of it works.
Prashant is not saying timelines, he's saying number of courts.
No, I know he's saying the number of courts, but I'm also saying that the very methods by which, the atmosphere and the environment within which the Lokpal deals is not a vacuum. He's going to enter into the same kind of environment that we are finding ourselves in today with the courts. I'm particularly talking about the lower courts. I'm not talking about the High Court and Supreme Court at the moment. So my problem is that you have an accused, you have a victim, you have witnesses. What happens when you don't keep to timelines? Because each one of these entities is prejudiced thereby. Again, I'm making the same point that you have to have some kind of consequence that flows from not following statutory provisions. And this question is not addressed, it's just left unaddressed. And that's as far as I'd love to know how to solve this, because I know it's a very pechida problem. The other point I just want to make is that round the room I hear every now and then this thing about we must change the criminal law to suit the inefficiencies of the system. Make the accused, presumptions of, forget presumptions of innocence, let's have self-implication, let's have more NDPSE, and I have seen that the human dimension of tragedy of a woman who doesn't know where the hell she is because she's in the middle of Madhya Pradesh and she can only speak Tamil and she can't get bail and she doesn't even know where she is and she's left her children on the platform. So please don't tell me all these things as shortcuts to fair trial. I really feel offended by it because I see that you cannot cut down on civil liberties and the notion of fair trial because you want to convenience judges who don't sit at their places when they should be, police officers who don't do the work that they should do. I don't mean to get all passionate, and I know that he's being very courteous to me and he would like to stop me, so I will stop. But I'm just saying that please take these things into account and let's not have throwaway remarks on what is the fabric of this country.
The last point in particular,
just one rider, one just rider I put on.
Age and seniority and wisdom over
I said after this one rider I just.
Well, while we can't deny the need to simplify procedures in the code of procedure, but I believe even with the procedure which is laid down, a trial can certainly be completed within a reasonable time.
Yes.
In fact, in some cases, newspapers have reported that in rape cases, some court somewhere in the country, I think 2 cases, one in Rajasthan, one somewhere in the south, from the date of the commission of the offence, the trial investigation was completed, trial was completed, and the man was convicted by the trial court within 3 or 4 weeks of the date of the commission of the offence. It can be done. But today the position is the number of cases which are loaded on a court is so large that he gives one date for one witness, then he has to adjourn it because he has to give dates in a large number of cases. The next date comes after 3 months. It is only if there are sufficient number of special courts that the trials would be complete in a short time. And this is the heart of the matter so far as this bill is concerned. Once the procession starts, once the people start getting convicted and start going to jails, only a few days back, the newspapers reported 5 top honchos of corporate houses have gone to Tihar in 2 cells of 10 feet by 12 feet. They are spending their days and nights when they are used to 5-star culture. Already I feel many of the corporate czars would be thinking, is it worthwhile to earn hundreds of crores even if there is some risk of spending time in those cells in Tihar jail? The day convictions start quickly and some people start marching to jails here and there, immediately there will be a drop in corruption. That's the day for which we are waiting for, which has not happened. All the corruption cases against politicians, one party is starting against the other, that party is started against the other party, etc. Keep on dragging. For 5 years, nothing happened. It is that malady which is attempted to be cured by this bill, namely the investigation will be completed in a limited time frame, the trial will be completed in a limited time frame, and that way immediately corruption will start going down, number of cases will start reducing. Thank you.
I think absolutely right, particularly if you add confiscation of properties also, that will solve.
Just one clause what Maya said. See, 231, this act was passed more than 100 years back. Session, trial, all these murder, all these cases has to go, it is to be finished same day. There is no choice. And today we are talking, I am working for human rights for good donkey's years. I am talking only exceptionally. Suppose you find property of 5,000 crore in the name of the minister. Should it not be presumed that this is illegally acquired? I am only talking of that say. Exceptionally. When you find property worth few hundred crore in the name of a minister or his relative, still there is no need for culpable mental state presumption. I am only talking exceptionally. I am quite aware of human rights. I am doing it for more than 3 decades now. Exceptional cases, as Anil rightly said, deterrent. You have to show that these people cannot go scot-free. Otherwise, trial would proceed.
I wasn't really responding
Only,
to that.
only exceptional cases I am saying. Where you find property worth your
That's not exceptional, unfortunately. I mean, I'd like to see them all in jail.
Actually,
they're not exceptional.
They're not exceptional.
No.
One very important and interesting provision in this bill, which many people may not have noticed, is we have provided that when some public servant is convicted for corruption, then the trial court is obliged to determine the loss caused to the public exchequer and apportion that loss among the different public servants who are involved in that corruption and recover it from their personal property. This is a very important provision in this.
It's a bit like False Claims Act, Ms. Hildar is talking about. Sir, I think we are in a happy position. 17 and 18, removal of Lokpal. Really, the government bill and the General Lokpal bill roughly are saying the same thing. General Lokpal bill is the amplification of what the government bill says. I don't see any serious contradiction there. And 18...
So there I have already mentioned right at the beginning,
yes,
that it should be a constitutional bill. Is the only way by which we can give them neutrality and independence.
I noted, sir. The reason why I did not mention that is the Judicial Commission that is investigating now is actually trying to overcome the impeachment, because impeachment is not often a single case. People have lost faith in impeachment.
No, but that gives you tremendous neutrality and independence.
But instead of adding to them, can we have another process? Because even judges, now these eminent jurists who actually, Justice Verma was one of the key judges who gave the judgment about appointments. Now they all realize that the time has come when appointments and removals must be by a different procedure, because impeachment unfortunately has failed in the country. Your point is valid, neutrality must be assured, but perhaps that mechanism has now outlived its utility, is the general feeling, except of the incumbent judges.
I find that they have given tremendous authority in the election. There are no doubts about that.
So, but what we have provided in this bill is that any complaint against a member of the Lokpal will be made to the Supreme Court, and they will constitute a 5-member bench to deal with it, and if the 5-member bench finds that there is misconduct which warrants removal, they will order his removal. So
I think this government bill also says it's 3-member. This is minor. Basically, it's the same thing that's being talked about. Right. There is a reasonable provision.
No discussion, JP. I just wish to say that when you finalize, kindly see the language used in NHRC Act Section 5 and Press Trust of India. So these two are happily worded. I say better worded for removal. It is same procedure.
You mean Press Council?
Yes. Yeah. Press Council. CVC also. So NHRC, this is happily worded, so you can see it when you finalize. Philosophically, it's same.
See, may I say one thing? I'm not very sure. I don't think probably that's provided. I think one thing which we need to expressly provide is no second term, even if the fellow has some time left to attain the age of 75. And secondly, no appointment of any kind which any government can give. And as a matter of fact, Gopal Swami, the letter which he wrote about the CC's office before he demitted, well, he also said that for 10 years there should be an embargo even on joining any political party or getting a ticket. I was asked, incidentally, in one of the interviews, what do you say to a chief election commissioner after demitting office, accepting a party nomination and becoming a parliament member? I said, well, I have first to criticize the former Chief Justice of India doing that. So I think we should not leave any loophole. Correct. No second term, and nothing with any government can get there. Correct. And if you are not prepared for that, then don't come. Correct.
Both these points there is general consensus, my lord. Everybody agrees.
I think it's already there.
Both these points.
Item 18, so the last item. Happily, Mr. Shanti this morning made it amply clear, and also Justice Venkatachalaya and Justice J.S. Verma. once the UNCAC is going to be ratified, even the anticipation of ratification gives the Union government and the Parliament the powers. Therefore, I think there is a consensus on that. Now, sir, we have the happy situation of 10 minutes before concluding remarks by you. Just a few concluding remarks of having any other issue which you believe is desperately important has not been addressed.
Property forfeiture was taken important. Yeah,
Funds for the
that can be done in 5 minutes. There is nothing much.
Yes, sir. Funds for the Lokpal and property forfeiture.
Yes. Property forfeiture, I think that Bihar Act is the best act. You can just follow that. They have really made good law.
Actually, forfeiture, I have one
also
suggestion.
covered in the.
I have one suggestion. Not only ill-gotten money, but anything to which it is, you see, supposing I take 100 rupees which is ill-gotten money and put it in a bank account. Personally, I think the entire bank account should go. You see, I mean, just as some rotten food, if you put in some good food, everything becomes rotten. I think, I mean, you see, the whole idea is unless at present it is a no risk and high gain business.
Yes, absolutely.
Unless you reverse the trend
Yes.
and make it, you see, no gain.
Absolutely.
Today, what happens is, how does it matter if I go to jail? I have provided for 4 generations.
Yeah, that is why forfeiture.
So, I mean, I think this is something which needs to be very harsh, because you see, once they know that it needs to be a deterrent of that kind, that the person is deterred by that fact alone.
I think if you don't want longer discussion, I just have 2 points on this. You can just consider the definition which is given in SAFEMA, smugglers and forfeiture, foreigners, forfeiture of property. That gives the definition, that is a very good definition which covers everybody under the sun. Your friend, relative, whosoever is holding property is covered under this SAFEMA. And the other provision is Money Laundering Act, which already has Prevention of Corruption Act, but unfortunately, it's a very smart move.
Law has been enacted, not notified yet.
No. In money laundering, prevention of corruption, 4 sections are mentioned. If you are caught with 500 rupees, that may be considered money laundering. But if you have amassed 5,000 crore, that is not covered. So that should be covered in that. That is more important to be covered. 13(1)(e).
Maybe you can also add Binami Act. That
Yes. Binami Act, there are no rules.
I would like clarification regarding a remark that Justice Verma just made. Did I understand you correctly, sir, that if I have taken a bribe of 100 rupees and put it in my bank account, which might have some other saving as well, does the entire bank account go, so just that amount which I have stolen?
That's the thought I put up for consideration. And you see, I mean, you may not accept it, but what I'm saying is, not merely that which was not due to me, but which I had legitimately, well, unless, I mean, that's the real punishment. I mean, it may be too harsh. I began by saying it may be too harsh. So please consider, don't go by that.
Okay.
But then,
no, at least I got you right. In that connection, I'd like to say that in the Lokpal bill, there is a similar provision, which to me sounds exceedingly draconian, which is for a private sector person who has benefited from corruption, then the recovery is to the tune of 5 times the amount gained. To my mind, that's right. It's the surety of punishment and the swiftness of punishment which acts as a deterrent rather than
You are right, Madhuji, that does, but this in addition, which means ultimately when you do that, you know that you won't only end up losing what you have taken, but something more. I mean, now whether it's 5 times or 2 times or you don't take the entire, that's a matter of...
I mean, penalties in addition could be provided for. I would certainly say, because if you misused your office, apart from recovery of the corruption money, there should be penalties. Yes. But I'm saying this too needs to be looked at carefully.
The quantum may be debatable, so long as the concept or idea of penalty. Penalty means you pay something which was your own and you are deprived of that.
And you bear penalty for misusing your office. Yes, but if you're going to jail in addition...
General Seko.
Somebody made a very interesting point at a forum last week where Justice Verma was present, a very senior civil servant, retired, that before taking up any assignment with the government of India, any civil servant coming into the government of India, after declaring his property, filing his return, he gives a power of attorney to the government, and anything found above this is automatically confiscated and reverted to the government. No, it's a very interesting.
Some probationers are said to be declaring abnormal assets even at the beginning, anticipating this problem. Really serious.
Yeah.
So, you know,
So what about the sources of funding? Are we discussing that of the Lokpal? Because that's crucial. I mean,
No.
there are some controversial provisions
we
here.
will flag it. Details is with the Consolidated Fund of India, because normally Constitutional Authority is only a charge the Consolidated Fund of India.
So
but some mechanism. But in real
but not
terms,
confiscation money going to Lokpal, because that should not even be
that probably will not be acceptable. Because ultimately all money has to go to the Parliament, the Treasury, and only Parliament can decide on expenditure except the Consolidated Fund of India. That's it. But just to substantiate Justice Verma's point, the other day in the United States, a couple, Indian couple by the way, Arun Sharma and Kiran Sharma, indulging in medical practice. He in medical practice, she managing the practice, found to be indulging in all kinds of malpractices. They were sentenced to 15 years by a Boston court, $43 million, their total assets, total worth, confiscated. It's harsh, but I think on that issue, the general consensus is better to be harsh once you're sure. At least in a few cases, because there is things have gone beyond a certain level.
Yeah, but you're hoping things will be coming under control. I'm saying don't make it draconian, make it stringent. And there's a difference between the two. That's all. Because everybody will then gang up to make it dysfunctional.
But it is subjective what you consider stringent and
Under False Claim Act, way back in 1860, Abe Lincoln signed, when you induce waste, loss and abuse, you attract three
I
times...
didn't go into details. That's the reason why actually our friends also incorporated 5 kinds of penalty. I understand, because deliberately we didn't go into details. In fact, Mr. Vinita Roy mentioned that. So there is a lot of literature on the subject across the world.
There's one minor thing. Chief Justices are here. What about law of torts? Do we have a view on this to introduce in India?
This is not the forum.
No, I agree with you. I'm just saying that will we ever give it a thought?
You may have a private discussion with the justices later.
Sir, a small suggestion to this forum, sir. We have skipped one particular aspect about the constitution of this drafting committee, which someone has...
That's not open to debate. See, something has been done now. It's our duty to take this forward and make this happen.
No, my suggestion is nothing to do... I'm not questioning.
No, don't revisit it, please.
I'm not revisiting, sir. Sir, I'm not revisiting, I'm not contradicting. I'm only giving a suggestion. Now that the court has issued a notice, we should intervene and we should strengthen this effort. Because government has, on one hand, Chidambaram says he is very cynical. Pranab Mukherjee says they are only toying with this unique idea for the first time in India. So, hence it's better to strengthen that.
Justice Verma made the point amply clear that this body stands solidly behind this effort to build a robust institution to fight corruption. What we discussed today is institutional linkages and instrumentalities. The intent is very clear, we're all solidly behind it. There are issues on which there are going to be divergence of opinion because India is such a complex country. Nobody knows the final answers. We have not deposits all based on. That's about it. Therefore, that's self-evident. But if you go into now composition, this, that, you are opening up a Pandora's box. Sir, before I request the two Chief Justices to make a few concluding remarks, it has been a fascinating discussion. We are very grateful to all of you. I owe a personal apology to all of you because I have been a little firm on occasion because the tyranny of the clock is something that cannot be avoided. And if we then go on meandering for the next 20 hours discussing but without any resolution, there is no answer coming through. And the reason why on some issues I have to be a little firm is that almost everybody sitting around this table, they have such rich experience that one word is enough for them to understand the whole context of it. We don't have to give them an elaborate explanation and anecdotal evidence. We are dealing with people of the highest caliber in this country with institutional experience over a generation and more. With those words, once again, thank you for a fantastic discussion. I think the nation is well served. I think the drafting committee, the political parties in the parliament would do well to take note of this discussion. We'll do our best to try and present a fair summary of this. All this is recorded. How much of it is going to be put in public domain, documentation, let's see, it's a logistical issue basically. But we'll do our best, all of us together. Thank you very much once again, Sir Justice Verma and then Justice Venkatacharya.
Thank you, dear Chairman.
May I convey a vote of thanks on behalf of all of us, to JP. Sir, before you start, I wish to tell that sandwich between two great judges, he has done exceptionally well. He gelled very well. You can form a now permanent bench, sir, something for the nation.
बहुत जल्दी असर हो गया brought down substantially.
बहुत जल्दी असर हो गया इनको तो एकदम ही I have just a few words. हमारे Justice Venkatacharya will speak more. I have only this to say, it has been indeed a beautiful experience. The most important outcome of this event has been the message which needed to go to the authorities that there is no division in the civil society. We are all one. And if we find some people on some issues, different viewpoints, it only means that everyone is thinking. Because when everyone thinks alike, that's not real democracy. And to give you an example, which you will bear out and the lawyers here will confirm, we realized very late after having been sitting together on the same bench for several years, by a stray remark made by one of our colleagues when Sharma was retiring. He said, these three are known to be very great friends, but find out one judgment in which all three of them are angry. And then we realized that it was a fact. There was not one single judgment in which all three of us had agreed. And of course, as usual, I was the usual defender. Starting with that V. Ramaswamy. So this is the beauty of this exercise. And I think the effort which some people have been trying to make to put obstacles in the task which was being performed by this committee, they would automatically be removed, and the effort in that direction, I am sure, will at least wane if it doesn't completely vanish. And I am sure, led by Shantubhushan ji, whose eminence and legal acumen could never be doubted as the leader of the team, I am sure they also would get that assurance which they badly needed because of some very unfortunate things which have been happening. And therefore, we must keep up this thing, and ultimately, if there are two views, that's what we have decided, that we will try to see that on every item there is a consensus worked out. Now, if a consensus is reached, fine, on that item, that's what we will record. If there are strong views which are not identical, then, well, the summary will show on this issue, these are the different points views which emerge. Because ultimately it is the parliament which has got to finally say what the law is going to be. The whole idea is, for the first time something is happening which has never happened earlier. You see, the parliament, before enacting any law, particularly the important ones, it must be open to everyone, because everyone in democracy has a right to have his voice heard and considered, and of course the deciding authority